Good evening, everybody. Now somebody's going to have to unmute and tell me whether you can hear me or not.
Yes, we can.
Excellent, good. Well, welcome everybody to the second of the Family Justice Council Expert Committee events. Just before we embark on the substance of tonight, some housekeeping. Can attendees, unless they're speaking, keep their cameras off and remain on mute for the entire event. We will be monitoring the chat bar, so if you've got any questions on either anything which you hear or independently of that, please feel free to put them in the chat bar and we will try to marshal them and take them at the end. The event is being video recorded and will be published on the Family Justice Council website in due course. And for any tweeters out there, you are welcome to tweet about it. And the hashtag we've been using is hashtag FJC Experts. So we've called this reprise of our first event, again, Experts in the Family Justice System, Widening the Pool. And we are joined, and I'm extremely grateful to our speakers for giving up their time this evening to take this session. So we have Dr. Adam Oates, a consultant paediatric neuroradiologist, who will be speaking on preparing expert reports for the family court and lessons learned. We have Dr. Jamie Craig, a consultant clinical psychologist, who will be speaking on the contribution of the psychological expert witness to the family courts, particularly topical at the moment, given what the President has recently been saying. We are then going to have a panel of three talking on tips and traps for experts. Maud Davis, who's on the Family Justice Council, Sharon Siegel, who was on our working group, and Fiona Straw, consultant community paediatrician, who is the paediatrician member of the Family Justice Council. And then hopefully we will have some time to take questions at the end. I see that some people are having echoes or not being able to hear. I hope that you're able to resolve those. I shall continue unless there's a clamour of in the chat bar to say that there are technical issues. Anyway, again, thank you very much for coming and giving up the early part of the Wednesday evening to join us. I'm not sure whether it's is it Great British Bake Off or Married at First Sight Australia tonight. Anyway, I'm sure we'll be finished in good time for everybody to watch their favourite TV programme or go to an exercise class or whatever else it is that everybody is also planning to do tonight. As I say, this is the second of our meetings and is a reprise of the session that we held in March of this year. The Family Justice Council subcommittee was formed as part of the implementation of a recommendation of the President's Working Group on Experts in the Family Justice System. And our first event was so heavily oversubscribed that we felt it would be useful to run the event again. At the first event, the balance of attendees was about 75%, 25% health professionals to lawyers. On this occasion, from scanning the attendee list, the proportions are broadly reversed. It's as those of you who have dipped into or consumed the entirety of the working group report, our recommendations are as important to take root within the legal community as they are within the health professional community and indeed more broadly. So I'm very pleased to see we have a good mix of attendees on this occasion. Just a little background in my introduction to what we're doing and where we've got to, really. The working group was formed, as I'm sure most of you are aware, shortly after Sir Andrew McFarlane became president of the Family Division, because of the concerns expressed about the shortages of experts to work in the family justice system, and those concerns really were nationwide and across a very broad spectrum of specializations. And so he asked me to chair a working group to look into the causes of that, and possible solutions. And so we brought together a working group who started work in January 2019, and the report was published 22 months later, COVID obviously intervening, in November 2020. The African elephant, as it happens, has a gestation period of 22 months as well. And although I'm as proud of our report as a mother or father elephant would be of their offspring, I don't pretend that it is as cute as a baby elephant. Since being appointed as a family division liaison judge, which was sort of almost coincidental with the publishing of the report, a lot of my time has been spent trying fact-finding cases involving many medical experts, and over the last 2 weeks I've heard evidence from 9 medical experts in a case involving the death of a young baby. One of the experts is the only court expert in his field currently operating in England. Of the others, one was undertaking his last case before his retirement, and another has retired from clinical work, although still undertaking some expert work, which I suppose illustrates some of the difficulties in themselves. Fortunately, though, other areas of expertise involved in my case was delivered by new faces, who I hope, well, I say new faces, new I suppose to me, probably not so new to others in the family justice system, but people who I hope will be around for many years to come, and who will be prepared to place their expertise at the disposal of the family courts over the coming years. Self-evidently, the issues involved for the parents, the surviving child, the wider family and society couldn't really be more serious in my case, and that expert evidence is of huge importance in putting together the pieces of the jigsaw which will eventually inform my judgment. And in so many cases, whether it's fact-finding in public law proceedings, or whether it's assessments of parents or children in private law proceedings, or whether it is evidence within financial remedy cases, across the whole spectrum of family cases and court of protection, expert evidence often plays a key role, and the shortage of experts causes delay, obviously, but also deprives the court and the parties of the opportunity to have the best possible evidence before the court in order to help the judges establish what the truth is, or what the best interests of a child are. So it's quite hard, really, I think, to overstate the importance to the family justice system of that expertise. Many of you will have seen that the president of the Family Division has recently issued a memorandum on expert evidence, which I think was published yesterday. And in his keynote speech to the Jersey International Family Law Conference, referred to the use of expert evidence, in particular in the private law arena, and the careful scrutiny that's required of applications to rely on experts. He drew attention to the importance of that in all cases, but particularly in the context of private law cases where there are perhaps allegations of domestic abuse and allegations of parental alienation. Although the working group identified 22 separate recommendations, which ranged from relatively narrow or ring-fenced proposals through to far more wide-ranging ones, we were optimistic when we published the report that some could be achieved in the short term, whilst others would be far more complex and aspirational. And the working group was converted essentially then into the Family Justice Council subcommittee. That was one of our principal recommendations, really, to ensure that the recommendations of the working group had a vehicle which could take forward the task of implementation of those recommendations, rather than us disbanding and leaving them to make their own way in the world. Happily, the Family Justice Council very readily accepted the invitation to set up that committee, and so now we have a permanent subcommittee drawn from the working group and from members of the Family Justice Council and other co-opted members who are overseeing the implementation of the recommendations. And I think we're fairly pleased with the progress that we're making with them. I think certainly for my part, I underestimated the magnitude of the task and the resources that would be needed to take them forward. But we are making good progress. Some of the recommendations in relation to difficulties experienced by experts in getting payment were addressed by the Legal Aid Agency even before the report was published, and a small subgroup led by Maud Davis is developing our action plan to address the remaining aspects of the working group and deal with other matters in this field. I would want to pay tribute to the input of Ellie Drucker from the Legal Aid Agency and the response of that organisation to our recommendations. Being a former employee of the Legal Aid Agency's predecessor back in 1986 to 89, when it was the Law Society who ran it, and having good friends still working there, it's nice to be able to pass on some praise rather than a brickbat. In relation to the recommendations about how the court could improve the way in which it dealt with experts within the judiciary, we have been exerting ourselves to disseminate the key messages in terms of communication with experts in relation to the provision of appropriate letters of instructions and proportionate amounts of materials, adhering to timetables given by the courts for the calling of evidence and the provision to experts of judgments at the conclusion of cases. That work will continue, and I hope in due course that the Judicial College training modules will incorporate learning in respect of the court processes, but also how the court treats experts in terms of their experience in court and in how they're dealt with in judgments. The course of the impact of the pandemic actually has almost by default led to the implementation of one of our recommendations, which was that experts should be able to give evidence remotely. That now seems to me almost to be the default position, and I don't see any reason why that will change in the future in relation to experts. And that was one of the particular issues highlighted in the survey that we conducted in the working group of experts, was the difficulties in attending court and the hold-ups in experts being heard if they did attend in person. I'm sure if we were all in person now, I'd ask for a show of hands, but I'm not sure whether I'm capable of doing that on here. But nowadays, it's pretty much the rule for experts to give evidence remotely, whether it's from their consulting rooms at their hospital or from home, and I hope that will continue. In relation to others, we are developing action plans in relation to the other domains. We've had discussions with or initial discussions anyway, with the Department of Health in relation to the pursuit of the recommendations relating to how experts are commissioned and the extent to which the Department of Health, NHS and CCGs can foster expert work, and whether contractual arrangements might be capable of being amended to support expert working. In Wales, they are independently making good progress with the relevant minister and departments there. Our subgroup is developing an action plan in relation to the extent to which the medical colleges and other professional organisations can support their members in conducting expert work through training and other resources. We are developing plans to liaise with others who train experts and who train legal professionals, the Inns of Court and other organisations like the Academy of Experts and the Expert Witness Institute, to look at what we can do together to ensure that aspects of the recommendations are incorporated into training for legal professionals and health professionals. The what we call the mini pupillage or court experience module that the Family Justice Council used to operate more vigorously, more extensively, has started to get into action again. I had last week, when I was hearing from a consultant neurosurgeon and consultant paediatrician, I had 3 paediatricians observing the evidence, and one of our recommendations is to extend that, and I hope that judges and lawyers will notify the Family Justice Council of upcoming cases where experts are going to be giving evidence, so that those who are interested in becoming experts or have just started on that path are able to get some real-world experience of what it is like giving evidence in a family court. And we are developing the Family Justice Council website to provide more information about the recommendations, their implementation, and events that we are putting on. One of my particular babies, was the establishment of regional subcommittees to provide a forum for discussions and mentoring, as well as local training for health professionals and lawyers, really to provide a forum where those involved or interested in becoming involved could get together and discuss matters of interest. We conceived it on the basis of geographical regions prior to the COVID pandemic, and so we have 8 regional subcommittees in each of the 8 legal circuit areas, which happily mirror by and large the NHS areas. And those have all sprung into action. We have a judge and a health professional co-chairing each regional group. They have drawn on lists of those who have expressed interest and have held, I think, in all cases, initial meetings. Some of them are further down the road than others, but they all look as if they're coming along, and the optimistic shoots are growing. And I hope over time that the combination of the National Committee and the Regional Committee and events such as this, whether formal or informal, will foster the interdisciplinary cross-fertilisation of ideas and understanding that the working group aimed for. Certainly one of the messages which came out of the surveys for me was the extent to which our perceptions differed as between the legal professionals and the health professionals. So a lot has been going on, but a lot remains to be done. It won't surprise anybody to hear that progress is slow, but I hope steady. All the members of the Family Justice Council and the subcommittee are, of course, volunteers, and we do have invaluable support from the permanent staff at the FJC, but there is so much to be done and relatively so little time to do it amongst everybody else's day jobs. So we're aspiring to the achievements of the snail. When we will cross the finish line, who knows? But get there, I'm confident that we will. I have to say one of the reasons why I remain so positive about our ability to deliver real changes is the huge enthusiasm of the health professionals and legal professionals to the importance of this work and their willingness to give their time and energy to furthering the work. And tonight may be one of the largest interdisciplinary get-togethers that has taken place, and that really lies at the heart of the working group recommendations. And so may we repeat this over the coming months and years at regional and national level. We will be holding a major event, we hope, next May, possibly a one-day conference to extend our training into a more in-depth sessions on particular topics. So keep your eyes open for that. It may be even that we'll be able to circulate to attendees today information about it. But that's the plan anyway. So I think I am now, I've used up my time. In fact, I've gone over slightly. So I will hand over now to our various experts who are going to take us through. And our first is Adam Oates, our consultant paediatric neuroradiologist. So Adam, are you there?
Mr. Williams? Yes, I am. Thank you.
Excellent. Good evening.
Good evening. There's a little bit of echo at this end. Are you hearing clearly?
You're on mute, Judge.
Yep, that was deliberate. So I can hand over to Adam. There we go.
Okay, so I'm hoping that everybody can hear me and see me. There is certainly quite a significant echo at this end. I hope it's not coming across to you. I've got a lot to go through, so I'm going to get started straight away. So as Justice Williams said, I'm a consultant paediatric radiologist at Birmingham Children's Hospital. I've been in post since January 2012 after training in Leeds, Toronto and Barcelona. And I've been providing reports to the family court since January 2017. I provide both reports on skeletal and neuroimaging, and say about 50 reports a year. I'm going to concentrate most of the time on going through the nuts and bolts of the reports, but just a few fundamentals to start off with. I think the big question when you're taking the first step in the family court is, are you ready for it? Do you have enough experience? And I think it's quite a nebulous subject as to what constitutes an expert. It's very difficult to find, and it's really dependent on individual experience, practice, which hospital you work at. I felt I was ready to take on the gun was when I spent 5 years as a consultant working at a large paediatric hospital, seeing lots of accidental as well as abuse and trauma. I think clearly, if you're going to take the next step, it's important to know the research regarding your particular area, obviously in my case, paediatric radiology, but also some of the limitations of that research and communicate that. It's really important to take part in internal external review, and I'll talk a little bit more about that later. But more practical considerations, how does it work taking on those instructions? In my case, a previous colleague had retired and he solicited my details and they approached me directly. In the first instance, that's usually by email, and the soliciting question was ask about your availability, whether the type of injury is in your professional remit. They'll ask about any conflicts of interest, typically for a copy of CV, and also any costs that you may charge. If you agree to take on instruction, and more importantly, the court instructs you, you receive a letter of instruction, which will describe the details of the case, the details of the injury to the child, and also filing date when you have to complete the report. Shortly after receiving the LOI, you receive a copy of the court bundle, and in my case, as a radiologist, radiological imaging, you provide your report based on that imaging and the other details in the court bundle. You provide your report to the lead solicitor along with invoices.
Adam, sorry, can I just interrupting? There's your voice is fading in and out slightly. I wonder whether turning your camera off might give you a bit more bandwidth.
Yeah. Is that an answer?
Let's carry on. Yeah, carry on, Adam. That sounded. I
should apologise. I'm actually speaking from a hotel in Rome at a conference, and that may account for some of the problems, but I will persevere.
I think that's slightly better, so yes.
Okay. Can you still see my slides?
Yes, I've got your slides.
Okay, so once the report is provided, that may be the end of the matter. In some cases, there'll be follow-up questions based on the various parties having reviewed your report. There may subsequently an experts meeting where other appointed experts, such as a neurosurgeon or a paediatrician, will meet, usually over the phone, to reach areas of agreement and disagreement. You may then proceed to a fact-finding hearing where you give evidence effectively in court. At the end of the process, there will be a judgment. What have I learned from my 5 years or so of being an expert in the family court? It's always important to be open-minded, not to be dogmatic in your opinion, and be prepared to change your opinion if certain pieces of evidence come to light. I learned very early on that if you change your mind and explain why you change your mind, then it's perfectly appropriate. The court is happy with that, so as long as you give an explanation. As a radiologist, it's important to recommend that you recognise that you're not the only evidence. There are other medical evidence and non-medical evidence as part of the judge's consideration. It's absolutely fine to recognise that you don't always know the answer, and it's fine to say that you don't know. It's important to recognise the limitations of your personal experience and also the research. I think it's also important to not be intimidated by the process. Clearly, it's fundamentally important to have respect for the court process, the complexity and difficulties of the decisions that have to be made. You shouldn't be intimidated by it. So I'm now going to talk about preparing the report. And I have a standard approach for preparing my report, and it's along the lines of a scientific paper, breaking it down into individual sections. I make it the language as clear as I possibly can. So if I discuss an anatomical term, I will define what that term is. If I talk about anatomical space in the head, then I will define that and give a diagram. As you see in my report, I also provide a copy of the radiological images. I believe that's useful for the court to understand where in the body I'm talking about. And when I'm preparing myself, giving evidence in court, I find it useful. It allows a review of the case before then looking at the images in more detail. As you see, I also provide a body map which indicates the location of the respective images. So this is a truncated copy of a report that I prepared to the family court. So you'll notice the upper left is a case number, and the case number is unique to each individual case. So it's important to use that, and it helps you in terms of preparing invoices and generally keeping on top of things. You can see obviously who I am, and then the right side of the page is the various parties involved in the case and other details regarding the data instruction and when what is due, etc. As I said before, there's a terrible echo at my end. I'm hoping you can hear clearly. So I'm moving on to the second page, and I'm hoping you can see this. But on the left side of the page, I give details about myself, about my training, about the places I've worked. I also talk about my practice as a radiologist at Birmingham Children's Hospital. That's obviously to give the court an indication of my level of experience and what is my normal day job. Over on the right side of the page, I think is a very important component of the report to me, and that's the executive summary. And obviously, as the name suggests, I summarise all the salient points of the case. I'll provide some background to how the child presents to hospital. I'll provide a summary of the radiological findings, then provide further background in this instance, the potential explanations put forward by parents. I then give my interpretation of the imaging and whether that explanation by the parents is appropriate or whether I think this is an abuse of imagery. And then the final paragraph just lays out in more detail how I'm going to structure the report. For example, I talk about the conclusion on page 31 and the questions posed by the court on page 32. So this is the way I always structure my reports. And because often you work with the same courts and the same solicitors over again, I'm hoping it's useful for them because they know exactly the layout of my reports and be able to read through it quickly. So again, just working through the report, I think it's essential as a radiologist to describe what images you've been looking at, so which hospital they occurred at, each of those images. That's always very good practice, just to describe exactly what you've used. Away from the radiological imaging, I describe the other materials that I've used. Often that would be the medical report provided by the local hospital. It will be medical bundle provided by the hospital, and also various statements. We then go to the page and start working through the radiological findings. And here it's an enhanced HTT, obviously data as specified,